विश्वसनीय सूत्रों से पता चला है कि आकांक्षा भारद्वाज की बहुत सी शिकायत जिला एवं सत्र न्यायाधीश अंबिकापुर द्वारा माननीय उच्च न्यायालय छत्तीसगढ़ बिलासपुर भेजे गए हैं. He also points out that my reporting author is continuously complaining about my, and this is the ground of because of this complaint only I got terminated.
All right, will reach.
प्रोबेशन का मतलब क्या? प्रोबेशन का मतलब ये है कि वी हैव टू असेस द कैंडिडेट whether he or she is fit for the job or not. The probation period of 2 years was given to them, all of them. After 2 years, a general assessment of all the persons were taken into consideration. Out of all the persons who were appointed on probation, we found that 10 of the officers are not suitable at this stage. So we extended the probation of all the 10 judicial officers. Remaining, whose assessment was good, they were already confirmed. These 10 probationer officers, these 10 officers were again, probation was extended. After the end of that probation, again assessment was made, and it was found that in this extended period, these officers had improved their conduct. These officers had improved their way of judgment writing. Their reporting authorities say that she does not have the capacity to write the judgment. And what the Supreme Court says in this Jammu Kashmir case, that even if it is taken into consideration, even if the complaint is taken into consideration, that would not give a right to the High Court to interfere, right to the High Court in a judicial review, because it is a simpliciter termination of a probationer. Because if the probationer is not confirmed, what would be the effect? The effect is that the person would not be continued in service by whatever nomenclature it has been discussed. Here in this case, it is a plain case of simpliciter termination in view of the fact that even after extension of probation period, the performance of the judicial officer was not up to the mark. That was the sole basis.
That's all?
Yeah.
Yes, madam.
ये रिकॉर्ड्स आपने बोला था, वो मैं फ्लैग कर दूं इनका अलग से या
हाँ,
पूरा दे दूं?
दे दीजिए, पढ़ लेंगे.
पूरा दे दूं?
Yes, madam.
Yes, Your
By
Lordship.
way of reply.
Yes, Your Lordship.
Pencil.
Yes, Lordship, Your Lordship. The Learned Counsel has argued according to Rule 4C9 of the High Court of Chhattisgarh Rule 2007, the Standing Committee has power to recommend the termination of the services of the petitioner, because termination is different from dismissal. He has clearly said that, but when we go through the bare reading of this rules,
है रूल है. Yes. हाँ, रूल.
this committee is the standing committee is made under Rule 2 Sub-Rule S. Standing committee means the committee constituted under these rules. And High Court is defined under Rule 2F. Court means High Court of Chhattisgarh. And this is defined under Article 216 of the Constitution. Here, the power of the standing committee is deal with in Rule 4C, where there are powers to recommend, which is specifically mentioned in Sub-Rule 2, to make a recommendation for promotion of subordinate judges to the rank of ADJs and the additional district judges and section judges to the rank of district judges and their initial in their posting on promotion appointment. Then 4, to make a recommendation. 5th, again deals with to pass order. 6th, deals with to pass order. 7, deal with to make a recommendation for the deputation of lower judicial services or higher judicial services to post under Government of India, Government of Chhattisgarh or other state government, or to foreign services. And then when we come to Rule 9, it says to pass order of suspension, initiation of departmental proceeding against member of the higher judicial service and subordinate judicial service, and consequential order in the said proceedings other than that of dismissal from service. Here it is clear written that to pass order, and recommendation is different from passing an order, because when authority in or committee passes an order, it means it is a complete authority to pass that to do that thing. And when we go to the service rule, where I was appointed, in which section Rule 11,
Yes.
Rule 11, sub-rule 2 says that the High Court may at any time before the completion of probation period extend the period Rule 4, the High Court may at any time before the completion of period of probation recommend termination. Here it is clearly mentioned that the recommendation should be made by the High Court. Here the Learned Council has recently stated two judgments, referred to judgments, this judgment of the state of Jharkhand and this Rajesh Kohli judgment, state of Jammu and Kashmir. In both cases, he himself read that recommendation was made by the standing committee, and that was the place before the full court committee, full court of the High Court, and then it went to the state government, and then the order of termination was passed. So he himself recently he read this thing that the recommendation is made by the High Court, not by the standing committee in this Jharkhand case only. And thereafter, thereafter, the Learned Council has stated in his argument that the deciding the confirmation of all 10 judges, including the petitioner, the ACR complaints, conduct comments by the reporting authority were taken into consideration. Here I first deal with the ACRs. The Learned Council stated that ACR for the year 2014-15 was taken into consideration. But in the reply filed by the High Court, kindly see the page numbers 400, 402, the para 20, in the last fourth line. Yes. It was written by them that the petitioner was awarded grade D, that is average for the year 2014 and 2016-17. And adverse remarks were recorded in the ACR. As many as 5 complaints were made to the district judge Ambikapur by Ms. Anju Gupta, ADPO, R.S. Shukla. He wrote about 2 ACRs, 2014 and then 16-17. And a document is also filed by the High Court in page number 410, where this is the, I think, placed before the standing committee. This document was also placed. Here they specifically written entries in the confidential reports for the last 3 years. Here they report year 2013-14, it was not recorded. 2014-15, D. And here they written 15-16, D. It means they referred this ACR also.
So you want to say that for recording their satisfaction that your probation should not be considered extended, they have taken into consideration your ACRs.
Yes, yes, my lord.
इसको clarify कर दूं, थोड़ा सा confusion इनको भी है. अगर पेज नंबर 410 देख लें, देख लें.
बताइए.
शायद इसके बेसिस पे आर्गुमेंट बिल्डअप करना चाह रही हैं. पेपर बुक का 410. इसमें 13-14 ACR not recorded. 14-15 D adverse remarks as per annexure A नीचे लगा हुआ है. फिर 15-16 D grade and remarks if any yet to be communicated. So 15-16 तो communicate ही नहीं हुआ, तो consider हो ही नहीं सकता. और 14-15 communicate हुआ है और जो इनके remarks हैं उसके नीचे लिखे हैं. By the district judge, knowledge of sphere of work, the officer's basic knowledge of law and instruction related to her function is average. Management quality, her management qualities mentioned in this point are average. Communication skill, written and oral, the officer communication skill both in written and oral is average. She is required to improve her ability to put her views and arguments both in written and oral. Appraising ability, the officer's skill and capacity regarding evaluation and recording performance of subordinate is an impartial and objective manner is average. So what was taken into consideration is 14-15 and the remarks. 15-16 का तो कम्युनिकेट ही नहीं हुआ. लॉ इज वेल सेटल की अगर ACR कम्युनिकेट नहीं किया तो आप तो उसको कंसीडर कर ही नहीं सकते.
Your Lordship, these remarks were advisory remarks. These were not the adverse remarks. But kindly see this 15-16 remarks. First, I wanted to go through the letter, but page number 249, annexure P9. Kindly see the actual what they have remarked in my 2015-16 ACR.
Yes.
Nature and quality of work. Please comment on the para 2 as filled out by the officer. As per work done chart provided by the officers, he has disposed of very less number of contested. Eventually, the officer has no ability to control the staff. Not only staff posted in her court, but also the ADPOs, advocates, police have complained orally many times and even in writing regarding her attitude and behavior. It is also mentionable that even the ladies ADPOs are not interested to work in her court. Quality of output, the officer's quality of performance having regard to standard of work comes to average category 6.24 unit per day for norms fixed by Honorable High Court. It has also been found that she has claimed units in those uncontested cases regarding which no unit has been prescribed by the Honorable High Court. Unless she will not take in interest to her work, she would not overcome from her constraint. Knowledge of sphere of work, the officer's level of knowledge of function-related instructions is average. Leadership quality, the officer's capacity to achieve target is not up to the mark until and unless she will not change her attitude, behavior, she would not be capable to achieve the
Yes,
target.
madam, you have already argued that point on like this. Now, please tell us what is the additional rejoinder you want to make submission?
Just a few minutes I will take. The comment by the Honorable portfolio in this this ACR. The complaints are alarming. The nature of bulk of complaints about behavior and judicial orders are not at all satisfactory. As appears, she do not hesitate to claim charges over on superiors subject to proof. And then he lastly pointed out she would not be able to discharge any other job. This comment is made by the Honorable Portfolio Judge that she is not able to discharge any other job. Any other job. This remark has been done, and this ACR was not communicated to me within reasonable time. Here there is a regulation.
This pertains to the period, which period?
14, 15,
15-16, which were not taken into consideration.
This were not communicated. Despite of a regulation, Regulation 7, 2007, there is a regulation regarding confidential rules where Note 7, Regulation 7, note says that it should be communicated on or before 1st of August.
Which page you are reading? Which page?
She is reading page number 249 and 250, which was neither communicated to her and neither taken into consideration. This is our specific case.
Yes, this specific stand you have taken.
Page 249 and 250.
250.
P17.
Yes.
Your Lordship, when we go through the regulations, Chhattisgarh Judicial Officers Confidential Rules Regulation 2015. Here, Regulation 7, preparation of ACR, in which note, it says every endeavor shall be made by the authorities in early finalization of confidential report so as to enable the authority of communicate the final conclude confidential report to the member of service on or before the 1st of August.
All right.
So why it was not communicated to me in 2016 only? And there is a specific guideline in Devdutt case. The Supreme Court has issued the guideline to communicate so that they can improve their work.
All right. This is all. So,
there are some more submission, my lord.
all right. We'll hear you after lunch.
Okay. Okay, Your Lordship.
Yes.
Your Lordship, kindly see page number 227. Here I have attached one notification by the state government where it says, अतः पुनः निर्देशित किया जाता है कि सेवा संबंधी मामलों में अनुचित जाति, अनुसूचित जनजाति, अन्य पिछड़ा वर्ग के अधिकारियों कर्मचारियों की गलती किए जाने पर भी सर्वप्रथम समझाई दिया जाकर उनकी कार्य पद्धति में सुधार लाने का प्रयास किया जाए। तत्पश्चात भी यदि सुधार नहीं होता तो उन्हें चेतावनी दिए जाए। इनके विरुद्ध अनुशासनात्मक कार्यवाही, गोपनीय प्रतिवेदनों में प्रतिकूल टिप्पणियां कोई ठोस आधार हो तो ही पूर्ण विचारोपरांत की जाए। इन निर्देशों के उल्लंघन के मामले शासन या वरिष्ठ अधिकारियों के ध्यान में आने पर दोषी अधिकारियों के विरुद्ध अनुशासनात्मक कार्यवाही की जाए।
Page number?
Page number 227. This is
Yes.
annexure P14.
Yes.
Regarding the non-communication of ACR, the Honorable Supreme Court in Abhajan,
Yes, that is clear. Devi Datta and everything is clear. Yes.
This will violate of Article 14 also.
Yes, yes, that is all.
Okay. Thank you, my lordship. Here, the contention is that I got average. My work done was average, below average during the for the period 2014 to 15.
Yes.
With the kind permission, I want to commit that regarding 11 Rule 11. Sub-rule 2 of this service rule, it says a person appointed to a post in category such and such shall undergo a judicial training for a period of 1 year. In accordance with the, here it is clearly mentioned that I went through a training for a whole 1 year. I joined in December 2013, 27 December 2013, and then for the whole year of 2014, I was under training. And the last training ended on 11th December 2014. That is also attached in this file. That is annexure P6, page number 71, 72. And on 31st January 2015, I got JMFC power. So I just worked for 2-3 months. So working for only 2-3 months, and the work done is calculated out of 220 working days. So how it could be possible to get good or very good criteria in my work performance? And this was not only the case of mine, but all 34 judges who were appointed at that time, all have got, I must say that all have this average work done performance in that ACR for the year 2014 and 15. And here the on another thing is pointed out by this learned counsel is that ACR for 2014 and 15, I was the only one, and one another judicial officer, she also got D. Rest of other did not got D. So here, because of my information I got through all judicial officer at that time, I came to know that all officers who got D during for this ACR for 2014 and 15, their probation was only extended. So that can be when Honorable High Court can go through the records and find out the truth that all the 10 officers were in ACR for 2014-15, they got D. This is the reason our probation period was extended. Now the submission by the learned counsel is that overall performance was taken into consideration, but then also he only pointed out that 2014 and 15 ACR. What about 15-16? What about my work done? I got transfer in May 2016 to Kanker, and what was their work performance? All these were not considered. That is also attached in my file.
All right.
So, and then, yes, Your Lordship.
Yes.
And about the comment, complaint, learned counsel.
You are repeating, madam. You already made a submission on the when you were given opportunity to make submission.
Sir, because this complaint is comment by the reporting authority. This is not complaint by an individual. That's why I just wanted to point out. You can
whether the complaint the comment made by the reporting authority has been taken into consideration. No. But if it has not been taken into consideration, then see.
Okay, Your Lordship.
I think you have argued at length very well.
Yes, that I have mentioned in my synopsis
clarification मैं
also.
कर दूंगा.
Yes.
इन्होंने पेज नंबर
One more thing, one last
Yes,
thing.
please go on.
Yes.
Conduct, about the conduct. I have 2 reporting authorities during my service tenure of 3 years. One is District Judge Ambikapur and another District Judge Kanker. While I got transferred to Kanker, there were no complaint in regarding my judicial work or conduct by the reporting authority or anyone from the this Kanker district. So this is my submission. And one more thing is that while we go through this complaint, one more thing, ADPO Anju Gupta, she in her reply, when I complained about her, in reply in page number 377, she clearly stated that विश्वसनीय सूत्रों से पता चला है कि आकांक्षा भारद्वाज की बहुत सी शिकायत जिला एवं सत्र न्यायाधीश अंबिकापुर द्वारा माननीय उच्च न्यायालय छत्तीसगढ़ बिलासपुर भेजे गए हैं. She also points out that my reporting authority is continuously complaining about and this is the ground of because of this complaint only I got terminated.
All right, will it.
The clarification है, she had referred page number 249. For a moment.
Yes.
249 date.
249. 249, yes.
It is dated 10/4/2017.
Yes. After the
termination.
That's all. Argument. Madam, written synopsis दे दीजिएगा आप. You may file written synopsis also.
About this, I have
everything.
already filed written synopsis.
Even if you want to say something more, you can give it in your writing. In your synopsis, there is no difficulty.
Okay, thank you.
Mr. Bharat, you also. Argument heard, reserved for judgment. The parties are directed to file written synopsis within 15 days.
Within?
Within 15 days.